Welcome. This is another in our series of SIEC webinars about virtual hearings in international arbitration. We're able to draw upon the extraordinary experience and expertise of the members of the SIEC Court of Arbitration, as well as our Users Council, both in Singapore and elsewhere. Collectively, the court and our Users Council have, I think at this point, literally decades, probably centuries of experience with not just hearings, but at this point, virtual hearings. They've been conducting them both in Singapore, in Europe, elsewhere in Asia, the Americas, and all around the world. And they've, through that experience, accumulated a wealth of experience that we at SIEC wanted to share with all of you, all of our users. Thanks in particular to the various members of the court, Kevin Kim, Hiroyuki Tezuka, Ariel Yi, Dinesh Dalin, and Darius Kambata for being with us here today to share their experience. Trust me, I haven't oversold them in the least, and we owe them a real debt of gratitude because of their willingness to take their time to share their experience with us today. Perhaps most importantly though, as usual, thank all of you, thank our viewers, our users from around the world. This particular session in terms of timing and otherwise is focused on Asia, but of course we will be having other sessions like this focused on other regions in the world. SIEC is, as I've said on previous occasions, a global arbitral institution with cases, with parties, with arbitrators from all over the world. And for those of you in either Europe, the Americas, elsewhere in Asia, that are interested in virtual hearing sessions focused on your particular region with the particular issues that arise there, please tune in to yet another session later this month. With that introduction, thank you again, and perhaps we begin with Dinesh. Can you give us some background about developments with respect to virtual hearings in Singapore, elsewhere in the region, based on your own experience?
Thanks, Gary. I think when COVID-19 hit from a very personal level, I had to myself used to technology very quickly, and was actually not so much in an arbitration in the midst of it when it hit Singapore bad in April, when all the shutdown happened, and I was just concluding a trial in the Singapore International Courts, commercial court, and it was quite an experience because I recall having the tribunal had 3 judges, and one was in Japan, one was in Australia, one in Singapore. Counsel physically in the courtroom, witnesses in China, and translation required. And I think this point that I'm making translates to arbitration as well, in the sense that one of the first things we did was we took the steps a week in advance. Let's test everything, make sure the systems work, and they did. But as fate would have it, things will go wrong during the hearing, and you need to be very flexible in terms of adapting to it dropping off now and then. I think there are difficulties for counsel in adapting to the cross-examination when the witness suddenly disappears, comes back again maybe 2 hours later, your train of thought, everything. So it was a learning experience for me. And I think that is something I'll be bringing back to arbitration. I had a hearing where I'm sitting as an arbitrator that had been postponed because of the pandemic. It was supposed to be a physical hearing. And now we're going to have the virtual hearing in about a month. And it's made me think a lot about the issues that may affect us as arbitrators as well as counsel with this new technology that we have to embrace. Firstly, the national laws. You got to get back to basics. Do the Singapore national laws allow for it? And I think in Singapore, we can say definitely, I see the answer is yes. There's nothing that prevents virtual arbitrations from being recognized. The second question I ask myself is, what about the relevant institution? What do the rules say? Because ultimately arbitration is consensual, it's party-led, it's party autonomy that rules. So, for example, if you look at the SIEC rules, I think the rule that comes into play is the one that says the arbitrator has the power to decide how the arbitration should take place, the manner, the process, the procedure. But that takes us back to the end game, enforceable award. So I think the touchstone has to be fairness ultimately. And that takes us to the nitty-gritty of the arbitration process using technology. Because as I mentioned, a hearing with everyone in different location, in theory, it's all supposed to work. But you will be dealing with so many variables. You'll be dealing with counsel, tribunal in different locations, witnesses, translators, transcribers, document management, making sure the witnesses might be able to see the documents as you refer them. Is that required? So when you think of all these variables, I begin to think that what you need, especially for complex arbitrations, where hearings are going to be filled with so many personalities and documents, you would need virtual bundles for sure. Secondly, you may need a technology manager for the whole process. Someone who really knows the IT to be sitting there helping you facilitate the whole thing. And yeah, just bringing it to the final point I wanted to make about fairness, really. At the end of the day, you need an enforceable award. And as I was thinking about these issues, I came across an Australian case. I think that could be instructive to all of us. It's a case of Sino-Dragon and Noble Resources Trading. A challenge was brought there to the Australian courts on the basis that technical problems impaired a fair hearing in the arbitration. And it was dismissed on those facts. But the truth is, if you read the judgment, is you'll find there were many problems. The planned conference tool did not work, and Skype had to be suddenly used instead. A split format was used with video via link and telephone conference as well at the same time for sound. Witnesses could not see the documents when cross-examined. An interpreter who was not qualified had to be replaced. All this was happening at the same time. And someone unknown, the court mentioned in the judgment, was with a witness in the hearing room. But ultimately, the court said on balance, the process was still fair because they felt that the party who was more prejudiced was probably the party who hadn't brought the application, and things sort of evened out at the end of the day. I think that case is something to think about, because what if the shoe was on the other foot? What if it was the party who the court said was prejudiced bringing the application? It suggests maybe you might have a different outcome. But these are the things we need to think about, because like another practical situation I was thinking about, you may have a different pandemic situation in a different country. For example, now in Korea, I think you can have meetings with people in the office. In Japan's the same with safe distancing. I presume a hearing could take place in that way as well. Now, but if it's an international hearing, what if half the parties are in Korea and can meet the arbitrator in his room on that basis or in a conference room, but the rest are, say, in Singapore? Do you want to, therefore, I think a question that comes to my mind is to ensure equality in the hearing. Perhaps you need to think about whether parties consent to that arrangement, or would it be better that everyone is virtual with the arbitrator as well to ensure that fairness or level playing field?
That's very helpful, Nash. There are decisions, in addition to the Sino-Dragon decision, I know there are decisions in a number of other jurisdictions, United States, England, elsewhere in Europe, that are quite explicit with respect to remote witness testimony. There haven't been so many court decisions to date in many jurisdictions involving, if I can put it this way, pure virtual hearings, because they're really a product of the pandemic. Nonetheless, the logic of many of these decisions, the US decisions, English decisions in particular, would seem to extend pretty easily to a virtual hearing. Those cases all involve remote witness testimony, which I think most, at least in my personal experience, and I think in most other practitioners' experience, is the most difficult part of a remote hearing, the cross-examination, as the Sino-Dragon case indicated, showing documents to a witness, being able to ask a witness questions in real time. But perhaps for another perspective from the region, Darius, your thoughts from your practice, both in India and internationally?
Hi, Gary. Hi, everyone. I think India in many ways is going to be deeply affected by this crisis. the sheer numbers, of course, and as India is slowly opening up from its lockdown, we are testing our systems and the procedures that are put into place. Bombay itself is still firmly in lockdown. I think courts and arbitrators are planning for the long haul. And at a certain level, though the human tragedy, of course, is awesome and we cannot turn our eyes away from it, there may be a silver lining to all of this as far as remote hearings and practices are concerned. As Winston Churchill, he's not too popular nowadays, I know, but he once said, never let a good crisis go to waste. And I think as lawyers, we shouldn't let this crisis go to waste either. The problem in India has always been the over-dependence on oral arguments, the oral tradition, less dependence on the written word, less packaging of arguments, long-winded arguments, no time limits, no written submissions in advance, that sort of thing. And I think that the opportunity now comes to set in place a system which will outlive the crisis and will outlive the coronavirus. And I think that's what our courts at least are trying to do. So the Supreme Court got into the act very quickly, issued a general order under its powers under the Constitution, effectively allowing every court in India to set its own procedure for remote hearings. And it declared that that procedure shall be valid in law. High courts, of course, had the constitutional power to set their own procedures, but other courts did not, and the Supreme Court conferred this power on them. And the high courts, particularly across the country, have now been issuing remote hearing protocols, rules, procedures. Some are very detailed. The Karnataka High Court has released recently a very detailed remote hearing procedure. The Bombay High Court and Delhi High Courts have also released procedures. There's also a fair amount of innovation going on. It's a very interesting order passed by a judge of the Delhi High Court, where obviously due to the objections of one or the other side, the High Court decided that each side was allowed an opening video clip of oral submissions of 15 minutes each, accompanied by a 3-page written submission, followed by reply oral video clip submissions of 10 minutes each, accompanied by a 2-pager on either side. And I think that perhaps assuaged the angst of the lawyers because they wanted their oral hearing and their day in court. I'm not so sure that's the right way to go because it cuts out the interaction that you still have in a remote hearing, but that's one of the solutions that was fashioned. By and large, Indian courts and Indian arbitrations are doing remote hearings. The platform is an issue, but I think that's a matter of trial and error. But these are usually confined to what are called urgent matters. So matters that can't wait, interlocutory reliefs, matters of that nature. In the last week or so, the Supreme Court, Bombay High Court, Delhi High Court have now tried to go into phase 2 to take up more substantive hearings. But the jury is still out on whether that's working or not. As Dinesh said, there are a number of practical things that are required. I can't agree with you more, Dinesh, on the virtual bundles or virtual compilations. I think it's critical now. Document management has always been important, but I think it becomes critical now to have properly paged bundles, to have proper bookmarking, to have everyone on the same format. All that is really now critical. And it might even require an institution or a court to set down a standard procedure or protocol. Of course, remote hearing etiquette is crucial as well. But I think all this has to be within the framework of law that a country gives you that permits all of this. The big question is, can you enforce a remote hearing, either in court or on arbitration? And I think as far as India is concerned, the answer to that is probably yes, provided the circumstances warrant and provided fairness is met. I know years ago, in a completely different context, in 2003, the Indian Supreme Court, in a criminal matter, allowed an application for a witness to be cross-examined remotely. The witness was in the US, couldn't come down. And the objection raised was that under the Indian Criminal Procedure Code, all evidence had to be recorded in the presence of the accused. That's a standard provision in most criminal laws all across the world. And the question was whether a remote cross-examination would satisfy the requirement of presence And the Supreme Court held that it did satisfy the requirement of presence with a few safeguards, such as ensuring the sanctity of the process, ensuring the witness was not coached, etc., etc. So we got over that hurdle a long time ago. As far as arbitration is concerned, the Indian Arbitration Act gives all the flexibility that you need for setting down procedure to the tribunal, subject, of course, to equality of opportunity and fairness. And I think most would agree that remote hearings with proper case management and proper safeguards would meet that test. So I don't think that this is going to be an issue. The legality of the process is not going to be an issue as much as the practicality of it and making it work. And the simpler we make it, the cleaner our procedures are, the easier it's going to be. There's a lot of writing on this, even within India. One of our most respected arbitrators, former Supreme Court judge, Justice Ravindran, has written a piece on the new normal in COVID times. And he has harked to the matter of arbitrators now deciding whether evidence might be necessary on particular issues, limiting cross-examination, doing away with evidence completely if necessary. All the powers that are always there in the rules, but have rarely been exercised. And he feels that the time has come that we have to look at these very usefully and carefully now. So it's a work in progress in India, but it's the main hurdles is the psychology of lawyers. Many lawyers are afraid by the technology of it. There's a fear of the unknown. And I think once we cross that hurdle, I think you will find remote hearings being widely accepted in India and upheld as being legal and valid. So there is a silver lining to all of this, I hope.
That's very, very useful update from another common law jurisdiction. Singapore, United States, England, Australia, India, all seem to be embracing virtual hearings, not just in arbitration, to be sure there, but also in their own national court proceedings. If national courts use virtual hearings, including over one party's objection, it would be ironic. It would be deeply ironic, in fact, if those same courts were to say that arbitral tribunals cannot do so and instead must stay the wheels of justice indefinitely until a so-called in-person hearing can be conducted. Kevin, can you? I know Korea is sometimes hard to categorize as civil law or common law, but can you give us a report from Korea and also, of course, from your own experience in other jurisdictions, whether Switzerland or elsewhere?
Thank you, Gary. I want to share my slide. I hope it works. Can you see my slide?
Yes.
So this is the slide. This is a photo of the general election recently happens in 16th of May, April. So that is, I understand this is the first and maybe the only general election during the COVID-19 situation. And we use various another technology like, the method that you have mask, you have gloves, have some process of make sure that there's no infection happens during the general election. And in a court, we now go to the court, and this is kind of witness testimony using the blocking the air contamination. So there's another photo. Just say actually this is more widely used before. So and using the video and just to have a written examination or make the argument through the video. But now in Korea, we go to court in person with mask And wearing the mask even at the hearing room, using the microphone. Microphone also covered with the other equipment. And so far is no report that this infection happens in infection that happens actually during the hearing or in the course of attending the court. So we are talking about the virtual hearing, and it is quite useful to have the virtual hearing, but we shall not underestimate the importance of the in-person the hearing, if possible. So we have to think about how we can survive and try to promote in-person hearing together with using the virtual hearing. That shows one of my experience. The other thing I want to share with you, based on my experience, is that in most cases when you have virtual hearing, sitting in Korea, we have issue of the different time zone issues, because many arbitrators or parties coming from Europe or the America, in our case. So, for example, if you are sitting in Singapore, the place of arbitration is Singapore. We're actually sitting in Korea 1 hour earlier. So if the 9 o'clock Singapore, 9 a.m. in Singapore means 10 a.m. in Singapore, and if you have 8 hours or 9 hours, the time, the duration, then you have 6 p.m. or 5 p.m. Again, this could be 6 p.m. or 7 p.m. in Korea. But that is the time in Europe is 2 a.m. in the morning in UK, and there will be until 11 a.m. in the morning in UK. So if somebody participates from UK, then the person starts the hearing at 2 a.m. in the morning and then end at 11 a.m. As the more serious problem is that you have a hearing, somebody joining from New York is totally opposite, 12 hours difference. So it's somebody sitting overnight. So if you think about the reasonable time period, for example, if somebody is going to participate from UK, 7 a.m. in the morning, it's still very early in the morning. I'm not sure whether somebody really can be prepared to start the hearing at 7 a.m. in the morning, but even though it's possible, 7 a.m. in the morning in UK is 2 p.m. in Singapore. Then you just maybe in Singapore people can stay until 8 p.m., which is 9 p.m. in Korea. So that is only 6 hours maximum, I would say. Otherwise, somebody said the very onerous time, and particularly maybe the witness, even the witness actually is going to sit for a day or 2 days. But in case of counsel and arbitrator, you have to sit there for a week or 2 weeks. It's quite difficult to stay living in a different time zone while you are living in actually living in a different place. So time zone issue is not just like it's a kind of a theory. It's more practical, very serious issue, and it may have impacts on the party's ability to present their case, and also have issues issues of the witness. The witness can or freely testify or the in a position make a proper testify proper evidence during the hearing. So the idea we are developing now is that we try to limit duration. For example, limit 3 hours or 4 hours per day. And then we just have more hearings. Because it's not that difficult to get together by video. So we just have 3 days in a row every morning or every afternoon or evening, and we come back next week or next month. And then that had related to the idea. Actually, I proposed the idea as a Gangnam arbitration principle. That is something like we have the hearing, we develop the case, and then based upon development of case, then we have another hearing. But the problem was that we have cost to get together, but now we have the virtual hearing. The virtual hearing is perfect situation where we use the Gangnam principle. Just say we have the hearing for 2 days, just 3 hours, and then we have another hearing next month, and have more, based upon the development, the case, we just focusing on the issues in a different manner. So I think it's the right time to think about if we have to live with a virtual hearing, we have to think about some the hearings, isolated hearings, and the several hearings rather than one hearing on the merit or the jurisdiction. So that is I want to share with you at this moment. Thank you.
Thank you, Kevin. That's very helpful, and the slides were also quite interesting, both for arbitration and otherwise. I think, drawing on my own personal experience, Kevin's observation about the effect of time zones and hearing length and structure is exactly right. I think for a fair number of counsel, a 4-hour Zoom hearing takes about as much energy, saps about as much energy from you as an 8-hour in-person hearing. One might think it would be the reverse, that if you were there in person, it would be more demanding, more exhausting. But at least my own experience and anecdotally what I hear from other counsel, other arbitrators, is that 4 hours of Zoom time equals 8 hours of in-person physical presence time. And so even if you do have time zones that are relatively aligned, I suppose in our international practice, they're never perfectly aligned, but assuming they're only a couple hours off in either direction, my experience is that hearings still tend to be a good deal shorter, just because people only have so much tolerance, so much patience per day to stare into their various computer screens. And as a consequence, one has to, as Kevin suggests, rethink the basic structure of hearings. A physical in-person hearing almost automatically defaulted to 8 hours, 9 hours a day, a number of days consecutively. If you're going to fly people from Korea, from India, from China to Singapore to be together for a hearing, it certainly didn't make sense for them typically just to sit there for a few days, rather have a consecutive block of hours over a consecutive number of days. But with virtual hearings, especially if you can only sit 4 hours, 5 hours a day, then you can, and I know many counsel, many tribunals are rethinking exactly what a hearing means. A few hours each day scattered over a couple weeks. I think one issue that we in the international arbitration community need to confront is whether, as some have suggested, well, that actually means you can have less hearing time in total. We can take what formerly would have been a 5-day hearing, 8 hours a day, that's 40 hours, and actually do it in like 20 hours. We don't really need 40 hours. I have to say, speaking just for myself, I'm quite skeptical about that. I'm not sure that remote technology means you can squeeze more content into a shorter period of time. And I think even though virtual hearings should pass muster, as I think all the speakers have said, in enforcement proceedings in most jurisdictions, that doesn't mean they always will. And trying to squeeze too much into too short a period of time, I think has some real issues, both with respect to fairness to the parties and opportunity to be heard. But here, Yuki, your thoughts from the Japanese, but of course also with your experience at Nishimura and Asahi more widely internationally, your experience with virtual hearings.
Okay, I would like to start with briefly commenting on the issue as to whether the arbitral tribunal can order virtual hearing over an objection by one of the parties. And my understanding is that under Japanese arbitration law, the tribunal has the power to conduct a hearing as it consider appropriate. So basically it's okay, subject to the general principles of equal treatment of the parties. So where, depending upon how serious or quiet the COVID-19 situation is in the different jurisdictions, one of the parties' council representative can get together in one room, like Korea, Taiwan, perhaps Japan, but the other party in a more dangerous country, one of my colleagues acted as a sole arbitrator, where one of the party comes from Middle East, where there was a complete ban, so nobody can go out of his or her home. So imposing a virtual hearing in that unequal situation may be viewed as violating the basic principles, but otherwise it should be okay under Japanese law, provided that if you look into the applicable rules of the arbitral institutions, you may find that the relevant rules say that where requested by a party, the tribunal shall have a hearing in person. So my understanding is that some issues have already been raised with the current language of the ICC rules, which may lead to require an in-person hearing unless both parties agree to the virtual hearing. So they may be revising the rules. And my understanding is that SISC rules do not have the similar problem, but you need to look into the rules. And I also wanted to mention that in the court case, maybe the same technology can be used, but there's one caveat. That is in Japan and in some other jurisdictions, witness examination under taking oath is considered to be an exercise of the sovereign power of the court. So if there is a virtual hearing for the US court to examine anyone residing in Japan, maybe the Japanese government position is that, oh, it is a violation, infringement upon Japan's sovereign power. So in the arbitration, there is no such issue. That in the court proceedings, you may need to consider whether the relevant country allow such kind of virtual witness examination. So having said that, I want to focus on my own topic, that is the interpretation or the challenges you face in the interpretation for virtual hearings. And you need to have some video conferencing platform literacy to smoothly conduct virtual hearings. And you need to have some understanding as to what you can do and what you cannot do. And in Japan, even though there is some concern about the security, Zoom has been used very widely by businesses and also by arbitrators, mediators. I have one case where I have already held 2 virtual hearings for one commercial mediation case. and on Zoom platform worked well. But you need to understand what you can do, what you cannot do. For example, you can share the documents on the Zoom platform, and you can highlight the document. You can use a rectangle or a border. But once you scroll the document, the highlight and the rectangular remain on the same place in the screen. So the highlight will miss the relevant part. So I would like to emphasize that the understanding of such requirements or limitation is very important, which means that in advance test run is crucial. You would be very much confused if you find that technical problems during the course of the virtual hearing. And having said that, in the case of the interpretation, Zoom has an interpretation function. So it may sound, oh, okay, Zoom will provide you the sufficient solution, but that is not necessarily true. So let me explain one by one. In actual arbitration hearing, people's preference are overwhelmingly for consecutive interpretation, even though some arbitrators always ask why you don't do the simultaneous. But in the simultaneous translation, it's very difficult to check the accuracy of the translation. So it means that consecutive translation, which may take more time and sometimes frustrate the arbitral tribunal, but you have the record of correction of the inaccurate translation, so it's much safer. And in the case of an virtual hearing translation or interpretation, if you use the consecutive interpretation, not much difference. That is, everything is done one by one. But if you are to use the simultaneous interpretation for virtual hearing, the problem is even bigger. And so to put a long story short, my current understanding is that Zoom function where the translator or interpreter can hear the original language, original voice, and the participants who need translation will only hear the interpreter's voice, wouldn't work for the simultaneous translation, but it may work as a kind of substitute for the so-called whispering translation, which you see many times, that is to assist the party representatives who don't understand the English very well, using the wireless microphone and the earphones, and translating in a very small voice, not to disturb the entire proceedings. So for that purpose, Zoom interpretation function may be used, but you shouldn't expect much as to the use of the technology for the simultaneous virtual translation. And my last observation is that depending upon the situation of the COVID-19, my expectation is that the virtual hearings in the coming months may be something like not a full-scale virtual hearing where everybody joins remotely from each place, but rather some people get together in the big hearing room of a local hearing center, and some people may gather in a local hearing center of the different jurisdictions. And then those two centers somehow connect with each other effectively. And some people need to log in from remote place each by each. But that kind of a hybrid type of participation, remotely and actually, may happen. And in the case of Japan, JIDRC, Japan International Dispute Resolution Center, the first ever arbitration specialty hearing venue facility, has been open since the last March. And they have some facilities where the breakout rooms can be connected via their own video link system. So if you cannot get the people, every people in the center, in order to achieve the fairness, perhaps one big hearing room for the tribunal and the witness, and then in one of the breakout room for the local councils, and then remote participation from other local centers, maybe one of the way to achieve some equal treatment of the party, rather than having only one of the parties present together with the tribunal. Okay, thank you.
Thank you very much, Hiroyuki. And you rightly emphasize the logistics, the practicalities of virtual hearings. Perhaps it's a topic for another webinar, but I think we've all had other speakers, Darius, Dinesh, Kevin have all mentioned this, but making sure that you have seamless access to documents, that you can draw a witness's attention in unambiguous terms to a particular passage in a document, making sure that you can interrupt a witness who perhaps, as witnesses sometimes do, isn't really answering your question, making sure that you can see the tribunal and gauge its reaction to both your documents and your interruptions is all critical. It's one thing to do that in a physical hearing when you simply have to turn your head, but virtually trying to make out a tribunal's smile or tribunal members smile or frown, and the little thumbnail pictures that we have, images that we have on our computer can be a challenge. I think many counsel, it's certainly been my experience, have turned to multiple screens for those sorts of situations. One screen for your documents, one screen for the witness and perhaps the tribunal, and one screen for your in-house consultations with your team, in order to try and make sure that you get all the various inputs that you would receive in an in-person hearing, and in an ideal world, perhaps even better inputs than you would in an in-person hearing. If instead of having scribbled notes passed to you or people whispering in your ear, you can actually look on a screen and see the more considered suggestions by your co-counsel or instructing counsel or whatnot, it frankly might be better than a so-called in-person hearing. I think Hiroyuki also makes another very good point about the importance of consulting institutional rules. I think many of us know ICC rules, Article 25, I think it is, has a requirement for an in-person hearing. Other rules, some national laws are similar. You certainly can interpret that as requiring a physical hearing. In-person means in physical presence. On the other hand, my experience has been a number of ICC tribunals, I think with some encouragement from the Secretariat in its equivalent of practice notes, have been interpreting in-person to mean virtually in-person. We right now are conducting this seminar in person, according to that interpretation. My own personal view is that although that might not be what people had in mind when they said in person, when the rules were revised in 2017, a virtual hearing really does provide all the same inputs as an in-person hearing, and thus that is a fair interpretation of the language. But it's still clearly an issue that one has to confront, both with tribunals and annulment and recognition courts. Ariel, we've had perspectives from a couple common law, a couple civil law jurisdictions. Your view from Hong Kong, from China.
Thank you, Gary. From Hong Kong, I'm now living in Hong Kong, and my understanding is that HKIC also conduct a virtual hearing, but I'm not so sure about the Hong Kong court, whether Hong Kong court is following other court in common law jurisdiction is doing that. Because one of the cases I had, we keep, told by my Hong Kong counsel that the Hong Kong court is closed since February until May. So both 3 months make no progress whatsoever. So this is something I can further investigate, so whether Hong Kong court is actually embracing this. But I want to follow what Hiroki just mentioned about the judicial sovereignty. It's always been the case if for litigation outside China, and if the foreign counsel want to conduct interrogation of a witness, within mainland China, the rule is always clear, which is you need to get a clearance from the government. And no matter whether it's a criminal case or whether it's a civil case, you always need to go through these lengthy procedures. And it's very often very difficult. So in the past, our experience for dealing with court cases, we always invite the overseas foreign counsel and ourselves to go to Hong Kong. And then we'll set up the meeting room in an international law firm, and we do the interrogation over there. It's always been the case. But now you have this visual hearing, the technology. And then the question is whether you do it online, whether it's, raise a question, whether it's a violation of your judicial sovereignty. I'm sure it is still an unanswered question. And to share with the international experience, I learned, first of all, last week, my colleague conducted mediation online. The mediation went 2 days. The one party was from Canada and the other party from Shanghai. And as Kevin mentioned about time differences, so therefore they initially scheduled 1 day mediation. It's been break into 2 days. So in the Shanghai side, they start the mediation in the evening and go all the way to the midnight. And then the second day, they continue in the early morning and finish by lunchtime. Afterwards, of course, the council said if they can repeat the same time zone, which is the first day they start from the evening to the midnight, the second day they're also starting from the evening to the midnight, that might work better. Because if you finish at midnight, you went home by 1 o'clock or 2 o'clock, and then you have to get up very early for the next day. But otherwise, other than that, the mediation went well. The Zoom provides them breakout room, so the parties can have intensive communication with the mediator. And the technology provides the Zoom lines quite stable. Another example is my colleagues in Sydney office. They're going to organize a virtual hearing with the parties from 8 different countries with 25 participants, and some of the witnesses actually located in a very remote place in one of the Southeast Asian countries. Because one party refused, resisted the suggestion to have a visual hearing. end up the tribunal believe that in order to maintain the timetable, they have to conduct the hearing online. The last example was from one of my lawyer friends. He was a barrister. He attended arbitration hearing, and he was there cross-exam a factual witness. They probably went in for about an hour, and then the barrister's assistant reminded the barrister, saying the witness was not really looking into the computer screen when he answered question. He was frequently looking to the right-hand corner of his computer screen. And then the barrister reported to the tribunal. The tribunal suspended the hearing and trying to find out what's behind the computer screen. It turned out behind his computer screen, there's a big blackboard with a lot of information on the board, trying to remind the witness what to say. So end up have to sort it out. So the reason I'm sharing this anecdote with the audience is because maybe in the future, as long as we're learning, how to conduct a visual hearing, maybe people want to put on in writing that no blackboard in the witness room. So those are the recent experience internationally, which I'm become aware. I'm going to have my first visual hearing on 2nd July. So I'm looking forward to that. In terms of domestic experience, actually 10 years ago, CTAC set up its own system, the entire platform, in order to do online arbitration. They called online arbitration in year 2009. They issued the guideline. The year 2014 or 15, they revised the rule. Initially, the online arbitration was designed to dispose of those online e-commerce transactions, such as the transaction with eBay or with Chinese Taobao. Those usually are small amounts, but a big amount of cases. And most of those cases were handled without hearing. So therefore, CTAC set up the online platform to accept filing, accept submission of documents, pay the fees, and even conduct online hearing. And afterwards, some other Chinese domestic arbitration institutions also follow that, and even the court. We have 3 internet courts, one in Hangzhou, Guangzhou, and Beijing. They set up the internet courts also to handle the cases involving the e-commerce. So it has always been the established practice that if you want to use the internet court or you use online arbitration, you have to agree to the rule in advance, i.e. you have to agree to accept that. Until earlier this year when we have this pandemic. So in February this year, the Supreme People's Court issued a notice to address those cases which were initially not meant for online arbitration or online litigation, and whether parties and court should do the virtual hearing. And if you look at the Article 2 of the notices issued by the court, it's made it very clear. One sentence read as, court must respect the choice of the parties. And then it said, if one party resists visual hearing, then the case has to be postponed. And it goes on to say, court is not allowed to conduct a virtual hearing without parties' consent. Of course, the literal wordings are not like that, but this is what it means. The court cannot make its decision to have a visual hearing unless party agrees. So following that, we see CTAC has its latest notice, and the Beijing Arbitration Center and Shenzhen Arbitration all have notice, all require that visual hearing can only be conducted if party has no objection. So RE, the domestic arbitration institution, is taking the position, is following the position of the court. So therefore, I raised the concern that for those international arbitration award, let's say you have the ICC or CIAC arbitration, and where one party resists visual hearing, but tribunal taking into consideration, all the factors such as referred in the ICC guideline, and make a decision to move on to have a visual hearing, then parties will run the risk that when you have the arbitration award come to be enforced in China, whether party may raise the challenge by saying either this is in breach of the parties' agreements or maybe on the public policy ground. So this is because the whole thing is new, and I understand that many international arbitration having visual hearing may not come to the stage for rendering award. So therefore, this is certainly potential risk and also issues. To prepare for today's seminar, so I put my outline into Chinese, and I'm going to send my suggestion by saying that maybe it's true for courts to have like a civil case, family issues, criminal cases, administrative cases. Maybe it's true that court do need to insist on having consent from the parties, but commercial disputes, particularly many commercial disputes, have is a document evidence heavy. For those cases, maybe the court can issue another notice to clarify, to allow the visual hearing decision to be made by court or by the arbitration institution. Otherwise, speaking personally, I have 5 cases supposed to have a hearing early this year. There's so far only 1 case the party agreed to have a visual hearing. 1 case, which is when party was from Canada as a respondent, and they refused to have a visual hearing, end up it's going to cause a serious delay. So therefore, this is one of the risks. At least at the time of my speaking, the issue hasn't been resolved. So any party who having international arbitration, having visual hearing with the Chinese party involved, should be aware of this potential risk. Yeah. Gary. Yeah.
Thank you very much, Ariel. That was very interesting. I agree entirely with you. It would be unfortunate if the Chinese court didn't issue a clarification about commercial cases, and in particular commercial arbitration cases. I think in most jurisdictions, the tribunal's general grant of authority, like that which you have under the SIEC rules, but also like what you have under the UNCITRAL model law in Articles 18 and 19, giving the tribunal broad procedural discretion, would be interpreted to exclude the possibility of virtual hearings absent some sort of specific agreement. I think in most countries, the tribunal's discretion, whether by virtue of institutional rules that give them the power to conduct the proceedings or by virtue of the law of the arbitral seat, extends to the decision whether to conduct a virtual hearing, even over one party's objection. And it would be unfortunate if all commercial disputes were basically put on ice until respondents said, we're happy to go forward. Hopefully there can be a clarification there. I think we're just about to the end of our allotted hour. Dinesh, you and your colleagues at Allen and Gledhill, any further observations before we sign off about virtual hearings?
I think we're all getting used to it, and I think we're all learning how to to address it, I think if I could just say a few more points about if there are any service providers out there listening to us, about a wish list really of things that perhaps could be developed. Some of them would be, it may already exist, maybe I don't know. For example, document sharing platforms, to what extent is the technology available for document sharing platform where you can, I think it's already been alluded to, and I think some technology exists, share a specific passage, point the witness, and you ensure everybody at the hearing can follow it at the same time. And one thing I thought about, how often happens when you're questioning a witness, that at times there may be an objection to that line of questioning for whatever reason. And what typically happens in an in-person hearing is sometimes you want to deal with that issue and the witness leaves the room. So is there a technology platform where you can get the witness to leave the room virtually rather than leaving the whole platform completely and having to dial back in? Other things could be like, is private communication possible between the parties during the proceedings, breakout rooms? And one thought I had is to minimize crosstalk, raised hand gestures, perhaps for the tribunal to see, for objection button or something like that. Because one concern I have about virtual hearings is what I find there's always a lag. And I may be speaking now, but someone who's hearing on another data speed, it could be that little split second slower in receiving. So that makes everything quite hard if you're all going to suddenly interrupt with an objection. Everyone's not going to follow it. So I wonder whether certain platforms to allow for that to be maybe in writing, you press a button, tribunal hears it, and they take control. These are just some wish list thoughts.
Darius and Kevin, your thoughts for concluding observations?
Gary, yes, we're pretty much on the same page on all of this. I think two important points. One is the traditional idea of a 5-6 hour hearing or a day's hearing will have to be relooked at. Not only because of the technological issues, but I think somehow it's more difficult for a tribunal to concentrate when it's a virtual hearing than it is when it's an in-person hearing. I don't know why that is. It shouldn't be, but I think that's a practical reality which we have to face. So maybe shorter sessions, break them up, and not have a 6 or 7 hour hearing at all. That will also address the time difference or the time zone problem. So that's one thing, yes. On hybrid hearings, there's 2 points of view on it. There is a strong point of view that a hybrid hearing might not be fair to the party that's participating remotely. So if you have a tribunal physically sitting in a room and you've got one side there in full strength, for the other side to participate only in a remote manner, or worse, to truncate their team and have partial participation in a remote manner, might not be entirely fair. I haven't really participated in a hybrid hearing as of now, so I don't know how it would actually pan out. But I think there is a fair point there to be argued that it might not be fair to have a hybrid hearing. You should either have a fully physical hearing or have a fully remote hearing. There are opportunities here. One little point I'd like to make, which Indian practitioners often face in international arbitrations. An Indian practitioner is always very anxious to have a fuller oral closing submission in an arbitration. And often that doesn't happen, precisely because everyone gets to congregate just once, and it's not practical to have a full oral hearing within hours of the evidence having closed, maybe the day before. You can actually then use this to your advantage in remote hearings, because it's, as one of the speakers said, it's easy to congregate in a remote hearing. So you can adjourn and maybe recongregate a week or 2 weeks later when everyone has collated the evidence and have a fuller oral closing. So there are opportunities here as well.
I think that's exactly right, Darius. I think that although there are differences between an in-person hearing and a virtual hearing, those differences aren't necessarily ones that make virtual hearings a poor substitute or an inadequate substitute. In some instances, they're actually strengths, advantages of virtual. And one thing I think, I'll come back to this in my concluding remarks, but I think one thing that arbitration practitioners need to think about is, what does the world look like? What does international arbitration, what do hearings look like after the pandemic is concluded? Do some of the things that we've started to do now during the pandemic, because we must continue to make sense afterwards, after we no longer must and simply can. I don't think we know the answer to that yet, but I don't think we necessarily want to go back to just doing things the way we did before, because we're allowed to. Kevin, and then Hiroyuki.
Yes, I just have one point that we have maybe clear distinction between two situations. The council and the tribunal, we don't have issue of integrity. It's even the council coach the other council, it doesn't matter, it's okay. So, but in case of witness or expert, we have integrity issue. So in case of witness or expert, we have to think about hybrid. They go someplace to make sure the integrity. It can be the arbitration center who participate and make sure that there's no coaching. Or you can go to some other place like a law firm or any place who can guarantee the integrity of the testimony. So as long as that is because for the technology, it's impossible to make sure that integrity. There's only the only way we can solve the problem is somebody just oversee to make sure that they don't no coaching and then they make sure the integrity. So witness expert, they have to go to someplace or they have to be with somebody else to make sure that the integrity. In case of counsel, an arbitrator, we can do that. We can do this virtual hearing as long as security is properly secured and there is a sufficient technology applied. So it's totally two different issues. I supported the idea of the hybrid hearing, and for the witness and expert go someplace, or the arbitrators, maybe arbitrators and counsel equally go to one place. We can do that, but otherwise we just have connect by video. But using the certain facility in one place for the witness and expert. That's my idea.
Yeah, that's very interesting and very, very helpful. Hiroyuki, your concluding thoughts?
Yeah, I want to say that at this moment, it appears that no single platform can achieve everything. So you may need to combine, such as a Zoom, together with the document management platform, and also with regards to the remotely placed members of the tribunal for an instant deliberation during the witness examination without excessively disturbing all the process. My colleague successfully used a chatting app called WhatsApp. So the nature of the deliberation is quick and simple enough. So rather than using the breakout room function of the Zoom, he said that it works well. So until we have the complete solution by one platform, we need to use parallel. And I don't know whether the good bug team is faster or good solution is faster. Thank you.
Yeah, my experience using WhatsApp as counsel has two warning functions. One, you sort of have to stare at the screen on your phone, which sometimes is a little obvious to the tribunal. And the second is things that you look at reflect in your glasses. So if you wear glasses, then you have to be careful about what you're looking at. I know some counsel, I've only tried it once, but some counsel have a separate screen that they use to communicate internally, either with a separate Zoom conversation with their own team members. I think just as physical hearings are a question of personal style in a way, how you organize your team internally, how you prepare your notes, how you prepare your PowerPoint, so how you participate in a virtual hearing, especially with your team, is a question of personal style. Ariel, any further thoughts from either you or your colleagues at King and Wood? Your anecdote about the witness and the blackboard came to mind when Kevin was talking about the risks of witness coaching. I know some people have a 360-degree webcam that at least ideally can capture things like the blackboard or the secret advisor to the witness. But any further thoughts from
yeah, two comments. One is about Kevin said integrity of a witness. In addition to using the 360-degree camera, another way people here develop is using notary public, which is enter into a confidential agreement with the notary public and asking the witness to go to the notary public's office to connect to the net and do the visual hearing. Then the witness will be supervised not by his own counsel, but by the notary public. That's one practice I can share. And I very much appreciate Dara's talk about the new norm. I believe that, say, my country is a big one, a lot of a population, and people invest a lot in the technology. I'm very much hoping that we can resolve the issue, which is you need the consent from the parties to allow the visual hearing to be conducted. And I'm also very grateful having this opportunity to listen to all the panelists to bring your knowledge and information back, and hopefully we can remove this obstacle as soon as possible.
Thank you, Ariel. I think we have time for a question or two from our participants. The one on the Q&A function on Zoom, we've had several questions. I think the ones that are easiest to address are the requests for citations to court decisions and awards, and we can certainly follow up individually after this session. But are there any other questions from the participants? One question I see is with respect to Andreas, if perhaps you and Kevin want to try to address this. For witness examination, how does one deal with objections, either because the cross-examination isn't relevant or touches on perhaps issues of privilege or is outside the scope of the examination? How does one put that in a virtual setting in your experience?
Well, I haven't had the experience, I must confess straight away. But I would assume simply raising one's hand, if that's a predetermined signal, should be enough to alert the tribunal and the witness not to immediately answer if you have an objection. I think these are the sorts of things that can be worked out in advance at a sort of a case management or procedural hearing, and maybe set out in a procedural order. So that everyone's clear about the rules and what the signals are. I think that's just a matter of modality, actually, just working it out.
Yeah, I mean, my own experience, for what it's worth, is cross-examining a witness is very difficult in any circumstances, of course. Cross-examination is one of the most challenging parts of advocacy. I think there's some particular challenges in virtual hearings because of the difficulty, if I can put it this way, in controlling the witness. If you have a witness who is inclined not to answer a question or inclined to make a speech about things that really aren't responsive to the question. Part of counsel's job, even though sometimes it ruffles feathers, is to cut the witness off, to tell the witness, because counsel has limited time, the tribunal has limited time, that they shouldn't talk about things other than the answer to the question. That, of course, is a delicate matter. Tribunals sometimes don't like counsel to interrupt a witness if, in the tribunal's view, the witness, in fact, is answering the question. Sometimes a witness, naturally, as a lay witness, may be confused, may not understand the question properly, and there can be a sense that counsel is either bullying or trying to force the witness to say things that aren't, in fact, really the witness's view.
Right.
We all have experience dealing with that, and it's not necessarily straightforward in an in-person physical hearing context, but in my experience, that's challenging in a virtual hearing context, because you don't have the same sense necessarily of the tribunal's reactions, number one, but also the same ability to, if I can put it this way, talk over the witness, keep the witness from talking. The Zoom technology with sort of two people speaking at once makes it more unpredictable, more difficult to control a witness. I think there are ways, as Darius says, to do that, actually. I think one learns a little bit how to interrupt. It's also a challenge, not just for the counsel that is examining the witness, but going back to the question, for counsel who has presented the witness who wants to object to an interruption of the witness by the cross-examiner. When you have then three voices competing, it can be difficult. All that said, as Darius outlined, I do think these are things that can be addressed in a procedural order, and that a good tribunal can help referee. Kevin, I didn't mean to interrupt if you had further thoughts on that topic, but if not, I think we're getting close to the end of our allotted time.
Yeah, I agree that this is quite challenging. One thing we may need is in this type of trend, Zoom connection or the other connection, we have the one speaker have a bigger screen, the other speakers have smaller screen, or you have all smaller screens divided. So you need some equipment, like each person appeared one full screen, so that we can see the reactions from witness or the tribunal members. So in that sense, again, it's hybrid. The hearing is a good idea, because you can buy and keep such an expensive equipment, but we have multiple screens to divide and allocate it to the particular witness or the counsel or the tribunal members. It's much better to have more like a in-person hearing. And in fact, when you're using the screen, full screen, you receive a lot of attention. You have you're always somebody watching you. So the character and the personality of the witness is really sometimes even better than actually you're seeing the person physically. So in any event, I just propose that we need some more equipment to make sure that particularly in the witness examination is more like an in-person the hearing.
I think Kevin represents some of the hardware manufacturers in the internet setting. A couple of our questions actually were answered by Kevin, at least in part. A couple of the questions went to how does one evaluate, assess a witness's demeanor? How can you tell if a witness is being credible in virtual testimony? Can you see the body language? Can you assess their expression satisfactorily? And I think as Kevin said, there's a real argument that you can actually see the witness better in a virtual hearing. Obviously, it depends on the webcam, it depends on the internet connection, depends on your own hardware. Bigger screen is higher definition screen is better. But I do think, based on my own personal experience examining witnesses, you can, in some cases, see the witness whose face is captured in a full screen image better than in person. There's also, of course, the point that some arbitrators make, which is, even in an in-person hearing, we're really bad judges of credibility based on body language and facial expression. You actually do a worse job in assessing credibility based on those sorts of things than if you didn't have them. I think, unless anyone has, any one of the participants has a further observation or comment, wave your hand if you do. We've gone a little bit past our allotted time, and let me say two things by way of conclusion. The first is, sometimes people say winter is coming, that international arbitration faces all sorts of challenges. Maybe, though, spring is coming. If it's true that national courts are putting the wheels of justice, especially in commercial cases, on hold, they're not conducting hearings, or if after the pandemic ceases, they go back to always conducting in-person hearings, physical presence hearings, perhaps then international arbitration has yet another benefit as compared to the competition, as compared to national courts. If we can harness virtual technology, and once the pandemic is done, use it to resolve disputes more efficiently, not needing to fly people to the Singapore International Commercial Court or the High Court in London or to the Beijing Intermediate People's Court. If we can instead do significant parts of the arbitral process virtually, that saves time, that saves money, and would perhaps be the beginning of yet another spring. That's, I think, something that remains to be seen. Ambiguities in the Chinese, perhaps other national legislation need to be worked out, need to be addressed. But my own personal view is that spring actually may be coming, even if it looks a little bit gloomy just now. The second thing I wanted to say, though, in addition to weather predictions, is thank you. Thank you again to all of our participants, Dinesh, Darius, Kevin, Ariel, Hiroyuki. I'm sure that our participants learned enormously, and most importantly, thank you to all of the many viewers from around the region, around the world. It was our pleasure, and we hope we answered your questions. Thank you again.
Thank you.
Thank you.
Thank you.